Carrie, in the last segment, I had asked you about whether alcohol could lead to automatism, this kind of involuntary movement of your body that leads you to commit crimes. I just wanted to give you an opportunity to finish that thought up.
Sure. And in our data analysis, we studied the cases where this was asserted. There were other cases where the court has found alcohol induced extreme intoxication. The Supreme Court of Canada could have shut the door on it. It specifically left it open and said that there may be cases where someone is able to dig up an expert witness to say that an automatistic state resulted from alcohol. So the jury's still out, as they say, although the court did say it would be an unusual case for sure.
Now, I want to talk about the legislative response. Daphne, I'll start with you. The government has introduced legislation in response to this case that would amend the criminal code in a way that they have called gap filling. They've said that it would ensure people who become voluntarily intoxicated are held legally responsible, but in a way that they say is constitutional and fair. So what is the gap that this legislation is intended to fill, and what exactly is this new legislation doing?
So the gap is that after the Sullivan and Chan and Brown cases, if a person became extremely intoxicated and could establish that they were an automaton, that they lacked control over their movements, they could be acquitted. It would negate the mens rea, as they say, and also the actus reus. It would negate both the criminal act and the mental element if you could prove that your intoxication put you in a state of automatism. So that was the gap, because they identified it as a gap because we want to be careful and talk about the dangers of intoxicated violence. So the new legislation replaces the section with a new 33.1, and it introduces like a criminal negligence standard. And so it says you could still be convicted of your offense of assault or sexual assault if you were an automaton, if you were extremely intoxicated, unless you satisfy the conditions of this legislation, which allows you to argue that it was not foreseeable that you would be put into a state of automatism by what it was that you were ingesting, that it was not objectively foreseeable that you would rise to that level of involuntariness, and furthermore, that it was not foreseeable that you would commit violence if you were extremely intoxicated. And so it allows an accused, and this responds to the constitutional question around having some mental element involved. It allows an accused to say that it wasn't objectively foreseeable that any of this would have happened. No reasonable person would have thought that.
So, Professor Frock, do you think that this law gets around the constitutional problems that led the old law to be struck down?
Well, it does insofar as the new law, as we've assessed it, is likely to be totally ineffective. So I imagine that defense counsel will have no problem with it. I don't know if there'll be any appetite to constitutionally challenge it if the Crown is never able to prove the foreseeability, both that someone would lose control and that harm would result. That's an extremely high burden for the Crown to have. So if the Crown can never prove it, there won't be any need for accused persons to constitutionally challenge it, because it'll never be an impediment for them raising the defense, which I think is risible to a lot of Canadians and to a lot of feminist organizations as well.
Yeah, I think what I'd like to dig into there is your criticism of the law. It seems like you think this new proposal doesn't actually fill the gap. Am I wrong, Professor Frock? Is that how you feel about this solution to the decision?
Yeah, absolutely. I mean, there's obviously times where an extreme intoxication defense is something that Canadians, I think, can accept. If a person is taking prescribed drugs as prescribed and they just have a wildly unusual reaction and it leads to extreme intoxication, I think people would say, well, there should be room in the law for them to raise that defense. But where you have someone who is reckless and taking an extreme amount of an intoxicant, was in the cases before the Supreme Court, I think most people would say, well, if it was foreseeable that you would lose control, and goodness knows what would happen, then that's something where you should have an accountability for what you did.